Welcome to the panel discussion on Internet of Things and IP issues. Before we get into what Internet of Things mean, where all it is used, it would be good to have a round of self-introduction from the panelists. I would welcome Dr. Schohe to introduce himself.
Good afternoon, everybody. My name is Stefan Schohe. I'm a German patent attorney practicing in Munich, Germany. I'm mostly dealing with data processing, computing, software-related invention, and of course the Internet of Things comes into this. During the last year, I was involved with certain talks with the EPO about especially artificial intelligence, blockchain, etc. And I hope to report some of the results today.
Good afternoon, everyone, and thanks for joining us. It's a Saturday afternoon, just after lunch. 4 parallel sessions going on, but you still chose to come into this room, so thanks for that. My name is Surendra Vyas. I am part of the Visa IP strategy team. Visa as in the Visa credit cards that most of you, I hope, would have here. And as a part of our role and our team, we come across a lot of IoT applications from a payment perspective. I'll talk a little more about that as we go ahead. And we come across a lot of things that we've been hearing since yesterday in this conference in terms of blockchain, AI. So all that is happening at some level, and there's an important IP aspect and connection to it. So we'll try to bring up some of that in the discussion today. As for me personally, I've been with Visa for a little over 2.5 years. Overall, I have around 15, 16 years of experience in various IP domains across big companies and small startups. So been there for some time, so I hope I'll be able to share something interesting with this panel today.
Thank you, Vyas. My name is Lakshmi Narayanan. I work with Samsung in the patent department. So our team primarily works on software patenting with emphasis on getting grants and enforcement in India. So my role here in this panel discussion is to sync up, connect all the points and find out what we can get as a summary to take home today. And I leave it to Jaya Pandeya from Lakshmi Kumar.
Hello, I am Jaya. I work with the law firm Lakshmi Kumaran and Sridharan. I'm an electronics engineer, a lawyer, and a patent agent registered with the Indian Patent Office. I've been a patent professional for over 12 years. And at the firm, my role involves patent preparation and prosecution relating to technologies like software, telecommunication, electronics, and similar technologies.
Thank you, Jaya. So we were originally 6 among our panelists. 2 of them could not make it. One of them, Dr. Vinayak from Reliance Industries, he has slides and audio for all of you today. And then we would like to have them here. Before that, we would like to discuss what the Internet of Things mean. We are all connected here as human beings today in a physical event. It's called conference. When human beings are connected over internet, it is called social networking. We get to know each other, we get new directions, we take new decisions. With that, we are able to grow ourselves and increase our revenues, make profits thereafter. That's the purpose of events and connecting together. Same kind of connection, when it happens with machines over internet, we call it Internet of Things. Why are they all connected? Devices have a lot of information, operational information. They are all connected. A decision is made on what to do next. That could result in new customer experience, new business experience, new business models, and then profitability, and then well-being of the society. So with that motive, how devices are being connected, we will look at. It's not generally in software, or it's not only necessarily in a house or any other environment. It is more prevalent in manufacturing industry. That's what Dr. Vinayak is going to explain to us today via his slides, how Internet of Things is deployed in manufacturing setup, what kind of challenges are faced. Thank you. Dr. Vinayak is the audio here.
Distinguished panelists on the dais, ladies and gentlemen, good afternoon. My sincere apology for not being physically present. I was so excited to attend this conference, but due to ill health, today morning I had to cancel all my travel plans. I am surely missing all of you and the lots of knowledge which I could have gained by attending the conference and the panel discussion today. I am going to briefly talk about how the IoT is going to benefit the manufacturing in a big way. Disclaimer is the slide where I say this is all thoughts are of mine, all presentation is my creation, and Reliance is nowhere responsible if anyone decides to adopt learning from this presentation. This is a common disclaimer and not a very new for the IP community sitting here. This is a little bit about the Reliance financial. You must have seen the third quarter result of the Reliance. It became the first corporate to cross 10,000 crore profit in one quarter. We are proud of that. How the industrial revolution is moving toward the smart manufacturing. In late 1700 or 1800, if you have seen, there was only a mechanization which moved from the manual operation where 100% replacement of assets were required. Then we moved to mass production. It continued, although it is in 1940, it continued till almost 60s, where 10 to 20% of the replacement of the mechanization could result into a mass production. But as we moved to the automation, which is 1914 and it is still today, it required almost a replacement of 80 to 90% assets, and that is why you see that old companies who didn't adopt the modernization have not survived anymore. And now we are moving from automation to the smart manufacturing. It is much beyond the operational excellence which we keep on talking in the industrial world. Mass manufacturing is something different, and when we make use of Internet of Things in the smart manufacturing, you will see in the subsequent slide what it can deliver. This is the fourth industrial revolution, what it promises. As you see, there are 20.4 billion connected devices which are going to be added in next couple of years. We've got artificial intelligence. Today, more than 70% data which we capture gets unutilized. We need to develop all our softwares using the AI, and it can create a huge change in the productivity and the reliability. Advanced robotics, which will be used for many operations and preferably, especially like a catalyst loading in an industry like us, which promises the productivity improvement by 30% by 2030. Augmented and virtual reality, where all the plant models, where people can walk in through the plant models and learn and make the changes and see the results. This is another huge revolution. And 3D printing, where you need not hold the large inventory. You can, small expensive part of a proprietary kind of things can be easily printed as and when you need. What IoT is going to do, just one example here, which is a early event detection. And the concept here is all the alarms or all the indications we get, which tells you what actions are required to be taken. But in a chemical plants or the refinery like Reliance or many other industries which run, where there are several parameters which lead to that alarm happening. And when you go to a early event detection kind of thing, where all these parameters, which is giving you the data on a continuous basis, is coupled into a software program. So which tells you the things which are not going as per your desire even before the alarms appear. Because sometimes it is too late to take the actions after the alarm appears, and this is one of the phenomenal things which AI will provide early event detection. Then what it can do, early event detection and other sensors and other IoT devices which we are going to use it. We see the couple of abnormal situations upset, people and work context factor 35 to 40%. This is the percentage by which the productivity loss or the reliability loss happens in the industry. Equipment factors are again 35 to 40%, and the process factor, which are 5 to 35%, which I am telling about this early event detection, which can take care. There are the other example where in industry we can improve the furnace length, we can address the chronic process issues, we can use robotics, which I already said. We can again use the robotics to have a coil residual life, so we know that how long plant can be run without shutdown. We can use the sensor to improve detect and improve the corrosivity of the highly corrosive material in the industry. We can do the operators training, which again I spoke through the AR, VR. And the plant design validation, which is very critical, that using of IoT at the stage of the engineering or the project implementation, which can again bring the plant while constructing itself to the highest level of reliability, and the condition monitoring and to machine learning. Today we do the condition monitoring, and what IoT can do is give us the machine learning. If you see the growth in IoT patenting, how it has happened, it was since 2007-8. Unfortunately, I could not get the data beyond 2013. But if you see the kind of see the slope of the graph, the kind of patenting which is happening in the IoT area in last 10 years is phenomenal. What are the IP challenges for me? Now, when we create software modifications, when we create the new models, the data privacy, it becomes a very critical. Because there are multiple agencies which are going to get involved. So how the confidentiality of data will be ensured when the data is going out of the premises of the organization? Who is going to own the IP? It's going to be another challenge. What are the patentability issue? How the IP will be protected? That's another thing which we don't know today. Maybe the august audience here, they can put some focus on this during the discussion. What are the possible solutions which we look at it? A creation of a strong contract management system. Then IoT by nature, it involves multiple partners. So can we have a digital agreements? And these agreements, the digital agreements where all the parties which are involved in the IoT will be legally bound for the confidentiality obligations. While we are developing the IoT or customizing the IoT for the requirement of the plant, the large number of modifications which happen. So ownership of IP becomes the issue in that case. So can IP law be revisited to bring the clarity on the ownership who can do that? And these are very brief presentation of some issues and the solution I have done, but there are many more which are going to come as we start implementing the IoT. But lastly, I would like to say the manufacturing, to remain a competitive, cannot survive the competition which is growing without the implementation of IoT. So it's not nice to have. It's going to be mandatory for the industries which want to be on the growth and the profitability path. So thank you very much. Once again, my apology for not being here. My thanks to the organizer for inviting me, and I look forward to attend the future conferences surely and interact with all of you. Thank you. Thank you very much.
Thank you, Dr. Vinayak, for remotely making a great presentation and setting the theme for IoT today. He mentioned that over 2 years, there will be 20 billion devices connected in this world. So we have to stay connected first to understand what kind of connections can happen in IoT that can impact our life. And he was also mentioning an important emerging area called 3D printing, which is really growing, and we agree with that. But the challenges that he was posing to everybody here, and that's also going to be the theme of the patent discussion here, is about data privacy, patentability of AI-related inventions, and also IoT inventions. So with this, it's not just the IoT implementation in manufacturing domain. You will all know that IoT is implemented in the form of connected homes. Within house, a lot of devices are connected. For example, if there is a microwave and there is a food getting overburnt in microwave, when the housewife is watching television, we will get to know in the TV itself that the food is getting burnt because the microwave and the TV are connected. So that's a small example of how human beings' small typical problems can be solved with the help of IoT inventions. Not necessarily IoT homes, it could also be connected cars. If we go via one highway, get into traffic jam, or there are a lot of potholes, the mobile phone can sense the potholes and send it to a common place. From there, the subscribers can understand that they should avoid such routes. Like that, there is also connected healthcare today. Artificial intelligence put together whatever the user is wearing, get data from everywhere and see what are all the health issues that he will face over a period of time. And then there are smart cities where we have difficulty in traffic and parking. So many such parking solutions are evolving. With this in the context of application, we will ask Jaya what kind of categories of inventions that come within the field of IoT.
Thank you. Thank you, Mr. Lakshminarayan. You actually nicely outlined what IoT is and the path-breaking innovations taking place in this field. Now, we've established that IoT is essentially things that communicate with each other. So there's going to be a network of things. Things will have sensors which will sense state or data, and this data will be communicated over the internet to an entity that will process the data to derive actionable insights from it. Because data in itself is nothing unless we can translate it into an action. So the way I see it, I'm not using the slide. We are following the panel discussion format. So none of us are actually using a presentation. I was just saying that the way I see Internet of Things, I think there are going to be 4 stages of it. And from these 4 stages, we'll see different types of innovations coming out. First part is going to be essentially about sensing of data, then communication of data, then the collection of storage of this data, and then the brain, or where the processing of this data will happen. So talking about the first stage, which is sensing of data, what kind of innovations will take place here? There may not be many large number of entirely new sensors in themselves, probably. But there are definitely going to be a lot of sensors with new or inventive features in them. So existing sensors with new features. For example, low power sensors, sensors that can communicate for a long period of time, consuming very low battery power, sensors that have communication interface. So at the first stage, these inventions take place. And again, the inventions will lie in hardware or in software. In the next stage, which is data communication, this is the stage where I believe a huge potential for invention lies. Because present-day wireless technologies are actually today not fully equipped to handle billions of connected devices with very stringent demand for low power consumption and very reduced signaling. So there are a lot of innovations being made to address that technical challenge. For example, we have Wi-Fi and Zigbee actually working on improving their capabilities so that they can handle low bit rate and they can handle reduced signaling. Again, in another example, we have companies like Audi, Tesla, and BMW that are trying to build communication interfaces right up to the consumer's home so that when the car is idle at night, it can download software updates. So demands from IoT is actually driving the next generation of mobile standards. Next stage that comes into picture is about data storage and collection. So like I explained, there are going to be a multitude of sensors sending in data. So we are looking at data coming in from a variety of heterogeneous sources at a very fast pace. So this is where big data comes into the picture. And innovations at this stage, that is data collection and storage space, are mainly going to relate to big data. And how efficiently we store our data is also going to determine how efficiently we are able to retrieve it and process it. So we can have new data structures. We can also have new types of storage media for this data. The next stage is where the brain of IoT lies. So like I mentioned earlier, data in itself is not much of value unless we translate it into an action. So we're going to have to process this data in new ways, faster ways, where there's fast extraction of patterns, and innovations at this stage are going to relate to data processing. And this is where IoT will converge with AI. So we'll see a lot of AI-related applications, AI-related innovations at this fourth stage of IoT. For example, our autonomous cars. Now, these vehicles ingest millions of events every second. You're actually going to need an AI-based tool, particularly a machine learning tool, to process that kind of data. And at this stage itself, there are, again, hardware as well as software-based innovations. Hardware inventions could relate to new types of processing resources. For example, we could have quantum computing-based processing resources as opposed to our conventional processing resources alone. So looking into the 4 stages of IoT, the types of inventions that are arising are very, very varied in nature. They lie in hardware, they lie in software, they also lie in a combination of the two. And considerations like the nature of the invention itself, the jurisdiction in which you want to protect it, who is the infringing party, these are the considerations that will help applicant determine what type of IP protection should be taken for this innovation. And IP protections such as copyrights, trade secrets, or patents could be availed to protect the innovations coming out of IoT. Thank you.
Thank you, Jaya. You rightly categorized the IoT inventions or processes into sensing, sending the sensed data, it's called communication, then processing the data for decision making, and then storage. She also mentioned the point, which is very right, that the IoT processes or the stages itself give rise to plenty of problem statements and result in development of new technologies. So that's where we are today. But for all these, what is there in the background is called data mining. And another term associated with it is called big data. I think not many of us are really clear about what these two. Let's ask Stefan about what does it mean in the context of IoT, the big data or the data mining?
It's one of the buzzwords that is sometimes difficult to put a label to. It's probably best to compare it to a database or to an Outlook record you have on your computer. So basically in Outlook, your data are ordered. You have a name, you have a profession, you have an address, and Outlook allows you to retrieve the address, retrieves the telephone number, etc., and you know it's assigned to this and that. This is ordered data. Now imagine, let's say, a supermarket or a shopping mall that gets millions of sales data every week. And okay, you have some information about, okay, when the sale was made, probably what was bought. You know the credit card number, possibly. Sometimes not, it was a cash pay. But somehow you want to know more about the people, and that's what the business people are interested in. Who bought what, when, at which time. And data mining now relates to techniques of having unstructured data, incomplete data, and to find something out that's hidden in these data. For example, you could imagine the task of searching the internet for pictures of GIPC 2019. Now, some are easy to retrieve, namely those where you can see a logo, GIPC 2019, but of course there are plenty of more. We are not always standing before a logo. And now clever algorithms can evaluate similarities. They can make links between different pictures. They can possibly, if they're well trained, spot that we were here at the Sheraton, at Bengaluru, from comparison with other pictures completely unrelated to this conference that is down there somewhere in the internet, etc. And actually, by not only evaluating the pictures of this conference, but all the pictures that are there of Bangalore, of the Sheraton, of your professional data as well, because you may make a link, somebody is involved with patents, okay, that may be related or something. Suddenly, you can retrieve pictures, you can recognize people, and then you can say, aha, these are the pictures of this conference. Or a bit more like a home application example, you have made plenty of pictures over the years, there are thousands of them, and actually you don't really remember it. You have maybe a diary, but you don't really remember what's what. And actually, you don't have the time to sort your 5,000, 10,000 pictures you've made over the years. Now, a clever software can come along and simply group this. So the software will find similarities. If you group, this was your holiday of last year, and this was probably the birthday party of your friend, etc., etc. So basically, without having any information about, other than possibly a date when the picture was taken, the software recognizes what's related to what and puts a structure into it. And that's basically what data mining is about. Put a structure to things, retrieve information that you didn't have before, and then, of course, the application is make this information useful for some purpose. Now, this purpose can be business, for the salespeople who know, okay, people who have attended this conference like to go to the shopping center after that and buy these and that things. Or it can be an image recognition in a security system. Okay, this guy may be a dangerous type. You may wish to check him. And it may be completely technical, and maybe in a car, that the car cameras recognize, okay, there's a grandma passing the street, and we should step on the brakes. So these are some examples when you retrieve from seemingly uncorrelated data, hidden connections, hidden information, which you then make useful for applications.
Thank you, Stefan. He made impressive points and with very clear explanation of what a big data is. It's all the data of common man. The profession, his address, where does he shop? It could be his location. All these are big data. What does data mining mean? Is all about giving a structure, understanding the pattern of the data. That's called data mining. When you put together, you can make big decisions. That's where we use artificial intelligence to create decisions or make predictions in future. So all these impact anyway the common man, either in the social forum or in the business forum. But what is common in both these forums is making payments. Why we talk about payments? Payments is revenue and then business as well as profits. Our Surendra comes from the payment innovation company. Let us ask him, how does he strategize inventions coming from the payments domain?
Thanks, Lakshmi. Yeah, so we heard a lot about various types of IoT, various applications. We have seen quite a few of them. So not all of them may have a payment use case or a requirement. So For example, I recently saw a video on LinkedIn where there's an IoT umbrella that's hovering on your head. You don't have to hold it. It's a hands-free umbrella. It's connected to your mobile. As you move around, the umbrella will move around with you. You don't have to hold it. That's an interesting use case of IoT, but it may not need a payment use case. Similarly, I saw a IoT suitcase on an airport. If you're moving around, you have to keep your suitcase with you, strolling with you. So it was, again, an IoT connected suitcase, which is connected to an app on your phone. It will just follow you around. You don't have to keep track of it. You will not even lose it. So there are a lot of things happening. All of them may or may not be of interest. But quite a few of them would have a payment use case. I'll come to some of them. But before that, it may be interesting to just quickly go through what a payment transaction looks like, what happens in a payment transaction. We all use credit cards, and in a fraction of seconds or in just a few seconds, the payment happens on a merchant location or on a POS device. But behind those few seconds, there's a lot that happens at the background on how your credit card details are sent to the bank of the merchant, who sends it to the payment network, say Visa or somebody else, and they connect to the bank, issuer bank, which bank issues you the card, and they authenticates you that you are the real owner of that card. And if that happens, then they authorizes and sees whether you have enough money in your account. If yes, then they sends back the response to the merchant POS device, where you enter a PIN, and then finally the transaction happens and the payment is done. So all that happens in a fraction of a second. Things travel across continents and data centers. So there's a lot that happens behind the payment transaction, which is not really visible to all of us unless you are working in a company like that. So, and even beyond that, once the transaction is done, you are off it. But again, there are things that are happening between banks. There is settlement that's happening, clearing that's happening. A lot of offers are generated based on the payment transactions that are made, like Stefan was talking. If you made a transaction at a restaurant in a five-star hotel, then probably you will be classified at a particular level of payment credibility, and you might be sent offers related to that. And similarly, where you are shopping, where you are visiting, what type of transaction you are making. Not only the payment data, there could be data around your geolocations, or even the type of pictures that you are taking, all that combined together to create targeted offers for you. So there's a lot that happens behind a payment transaction and after a payment transaction. Now coming back to an IoT use case, what would be the use cases where an IoT may need a payment transaction to be done? So some cases that I said earlier may not need, but the cases which may need very commonly are, say, things in a smart home. We talked a bit about that, a microwave or a refrigerator. These days we already have devices in the market, some of them from Samsung itself, which have payment capabilities. A refrigerator can order milk for you, can start ordering bread for you daily. You can set up things on that. You can set some rules on how to place an order. Similarly, a microwave or a washing machine can order detergent powder when it's over, whenever you set the alarm accordingly. But that can happen because it is connected to the internet and can send commands and directions. But how will the payment be done for that? So there are various technologies that are coming up to facilitate that. And how does a payment in a human-assisted transaction versus an IoT-assisted transaction be different? So first of all, how do you authenticate? And how do you provide the payment capability to the IoT device? So the devices that have payment capability, as an owner, there's something called tokenization, the whole concept of tokenization. There's a whole technology around that, how you tokenize or mask your credit card numbers and save it onto the device, so that device can use that token and make a payment transaction or initiate payment transaction. So if I buy a microwave through an app or through a web link, I can send a token of my credit card to the microwave. And then there could be innovations around hardware on the microwave or any other device on how would that store the token. So even if you're using any payment device on the phone, so Apple Pay, so your credit card is tokenized and stored on the iPhone device, and then you can make payments through that. So there are things around how you tokenize that for processing. That's different in a human transaction versus a IoT transaction, the tokenization effect. The authentication effect, how do you authenticate that the device is the right device which is sending the payment transaction, is meant to send the payment transaction. Like I said, for a human transaction, there could be a second factor authentication. We all use OTPs or some other ways to provide a second factor authentication. How do you do that in case of a device to ensure that the device is the right device to make payment. And it's not only second factor authentication these days, it's what is called adaptive authentication. So if it is the bank is very sure or the network is very sure that you are the right person, it may not even ask you for a second factor authentication. But if they are not sure, they may keep asking you for multiple levels of authentication depending on the various parameters they are doing. So there are things coming around in second factor authentication or adaptive authentication for devices, which may look at the location of the device, which may look at the other devices that are connected to that device in that location. It may query some other devices to ensure that this is the right device that is to make payment. Or it may send a notification to you through your mobile phone to authenticate that you want this device to make payment. There are various ways to do that, and that's one aspect of the payment innovations around IoT payments. Even it looks at device fingerprinting, various aspects of the device. So these are various strategies and various innovations around payments in IoT that we are looking at, we come across regularly. And one more last point that I want to add is around regulatory issues, data protection. We've all been talking about it. So as we said, in case of a human, you are the one who is going ahead and sharing the payment transaction, payment details, card details. But in case of a device, how do we ensure that the data that is stored on a device is safe and conforms to regulatory requirement? That itself, it's a big space where a lot of innovation are happening in both the hardware and software space. So we try to combine all of these things and come up with innovations in IoT payments.
Thank you, Surendra. I think you gave great insights on the visible versus invisible inventions. I hope we all know the visible inventions are from machine to the human being. Invisible inventions are from machine to the server. So usually it is understood that the visible inventions have very high infringement detectability, and therefore companies tend to protect them with more emphasis than the invisible inventions. Some companies keep invisible inventions as trade secrets too. He gave another point is the human assisted payment and IoT assisted payment. I think we are moving from the human assisted to IoT assisted payment probably, and then adaptive authentication, which he mentioned. That's what happens with Ola and Uber. When we travel, we don't do anything. The moment we get down, the payment automatically gets deducted. So that's why wherever the common man is getting benefit with the name of simplified UI UX and then fraud prevention, easiness of making payments, those are the areas I think Vyas explained where the inventions are developing, and that's where people are also strategizing. With this kind of environment where multiple devices, multiple parties, multiple parameters, factors that are being considered for developing IoT inventions, Stefan, what do you think are the challenges in really protecting these kind of inventions?
Well, one of the challenges we definitely have is the distributed nature of things. To do this data mining or to do artificial intelligence things, you need big computing power, and usually you do this in the cloud somewhere, and you have a data center with plenty of computing power where your processes play the result back. And then you have somewhere a terminal device, a smartphone, or just a normal computer terminal where you receive it. Now, obviously, both are not at the same place, and sometimes the server is not even in the same country, which raises a problem with patent law because patent only protects things or activities that are or take place in a specific territorial area. Usually, the state of the state that grants the country. With the former UPC, it will be more than that. With the UPC to come up, it will be more than that. But there's always a certain territorial area to which the patent is limited, which is good in a way. However, when you come to IoT, the difficulty arises because your server may not be in your country that you're interested in. You make a transaction in India, and the server may be located in the USA or in Germany, or let's say on the Bermudas, which is not specifically known for patent coverage. So how to go about it? Basically, you cannot claim the entire system. And so what the traditional approach is, you claim parts. So you say, okay, maybe I make a claim to the system just in case everything is in India or Germany or USA. And then I make a second claim to the server, and I make a second claim, third claim to the terminal device or to the client. That's a traditional way of prosecuting distributed systems. However, every claim you make must contain a patentable invention. Now, if you have a process where part of the data processing is done in the server, part in the client, that's not exactly or usually not an issue, because you say, okay, I claim a client device performing this and that method steps, and I claim a server doing this and that method steps. Fine, patent office grants it. But what do you do in the cloud? When all the computing is happening in the cloud, that is in the server, and all your smartphone or your terminal device does is sending information and receiving information. And actually what's special about it, you can take any computer terminal from the rack and connect to your cloud. And so if you say, okay, I have a terminal device that receives certain data, sends certain data in response to signal received, so the patent office will probably say, well, you're claiming something that exists, you will not get a claim for that. And that's actually where the trouble starts, because usually you may not have access to the server, so what do you do? Okay, one thing is you claim the use of your client device in a patented method. Now that's fine in principle, because you don't patent the device as such. But you say my patent protection only starts when somebody is interacting with the cloud. Serves the purpose. However, with many applications, that's not the protection you want. Because let's assume a commercial application where basically Amazon has a platform or whatever. The person handling the terminal device is the customer. First, you don't want to sue the customers because the competitors' customers may be your customers. That's one thing. And the second is, well, there are millions probably of people who are infringing. What's the good of chasing one user if there are trillions of other users out there? So that's limited. It may possibly help when you have a big entity with a big server, let's say a bank doing transactions with a server somewhere else. That may help. But if you're talking about individuals, that's not really helpful. The other thing is you can say, okay, I claim a method, and then you may hope that the infringement judge may say that the participation in a patented method, at least if it takes place, partly takes place in a jurisdiction, could be an infringement. And that's actually more of an infringement issue than a prosecution issue. We have had a couple of decisions in Europe on this, and you can see that the judges struggle hard to find infringement. However, it's difficult to put this into a single concept. There is one approach that says, okay, the person that controls the process is infringing. That's the approach taken by the UK courts in the Menashe decision. Another approach that was taken by a German court is that, well, we look where there is an economic impact of the use. all of which has not been settled case law, so that's a bit experimental. But as I usually say, well, if you have to be creative in these things, and if you don't try, you will not know what works. But that's something that you would typically do. You claim the method and hope for the best in infringement. There is also another thing that could help that you have in most European jurisdictions, that if you claim a method, you can allege an indirect infringement, and the concept of indirect infringement in Germany and Europe is as follows. If you deliver something, actually it doesn't have to be physical, could be software, that is suitably intended to be used for an infringing purpose, then this in itself constitutes an infringement, and the beauty of our provisions in Europe is that you don't even have to prove an actual infringement. Now, that helps you a lot with software, with the software providers, because you can sue them, and that's what you want. You don't want to chase the individual users, you want to chase the software manufacturers. That sometimes helps, but again, there is a territoriality issue, and unfortunately, indirect infringement has a link again to Germany. The invention has to be intended to be used in Germany or actually used. So again, if you have these distributed things and you are on the wrong side of the server-client structure, you may be in bit luck. Another thing that you may consider is a signal claim. That's, again, something experimental. I don't think it's used on large scale, but the European Patent Office has for a long time accepted that a radio signal is a patentable entity. Although it's transient, it's not permanent, but it's a physical phenomenon, and if you structure a radio signal in a certain way, then you can get a patent on it. Actually, the case was about a specific format for a television signal, but now you can think, okay, I have my server here, I have my client there, but what's going in between, and which is actually on both sides, is the signal that's transmitted between the two, and you may think of patenting this signal. It's a bit of an experimental thing right now, but that's certainly something we'll try and see what the Patent Office will say to this, and at a certain point in time, what the infringement courts will say on this if the Patent Office accept that. Third issue to which we may get later, final issue that we may get to later, is actually the enforcement in a distributed system. And now let's, because the client and the server may be operated by different people and usually are. And so how about multiple parties committing infringement, especially if they're unrelated? And I can say as much that the courts in Europe have started to deal with this issue. There have been first decisions that actually held that even if you don't know the other party that's completing the use of the patent, you may nevertheless be an infringer. And I think I'll leave it at that.
Thank you, Dr. Stefan. I think Stefan mentioned the traditional way of claiming. If several devices are present in an IoT environment, people have been claiming each device individually. But what is the drawback there? Each device may not be novel at all. That's well known. Only in a combination, the IoT inventions appear to be novel. So that's the drawback. Then what people attempted is next time a computer communicating with a server. Together, people were trying to make a claim out of it. But then what happened? It will help major businesses who own both entities or who have tie up with both the entities, but as an individual, it's not going to help. So not only that, with the ecosystem, people also made an attempt, we have to make an attempt to make sure that the claim also make sure that there is an infringer for it, and all the steps in the claim must be infringed. So keeping that in mind, then it becomes difficult to really make a claim. That's one of the challenge. So the recent court cases have said if the defendant has a controlling stake in the operation, that he is an infringer. So those kind of things are considered. Still, there is a little not so clear area, but Stefan was mentioning very clearly that recent days, European Patent Office has been accepting signal claims if it has been structured well as an entity. Otherwise, earlier signal claims were dangerous and were rejected. We were not even using the signal claims. Thanks for such kind of insights, Stefan. Given that there are so many participating devices in the ecosystem, naturally there will be many suppliers, service providers, lot of collaborating parties towards development of an IoT invention. In such cases, let us ask Surendra, how does he consider IP sharing arrangements? Really towards, there are many, it's called open innovation. There are many ways companies source inventions, ideas from outside. But unless there is a proper IP arrangement of sharing, then it becomes difficult to progress further. Let's ask Surendra, how do they do it?
Yeah, thanks, Lakshmi. Yeah, I don't have a right answer or a long answer to this, just a few thoughts and comments. So like in other cases of open innovation, in case of an IoT also, there are various stakeholders that have to come together and build up something or create something new. And from our side, when we are a part of that group of stakeholders, our key concepts that we are bringing on would be related to payments. And as I said earlier, some sort of tokenization and other things. So obviously, the main thing is about getting the right contracts and agreements in place, that who owns the IP, what are we going to develop. The one thing that needs to be done right is to ensure before you get into any sort of development that what are you bringing to the table from your side? What is it that you've already developed, is already known through your patents or know-how or publications or trade secrets, so that it's very clear that this has already been done by you, this is what you are contributing. And same for all these stakeholders, so that it's clear for all the parties that this is already known, this is already done. And whatever we create beyond this would be sort of a joint IP, and then comes the question of who owns what, which may be defined through the terms of the agreements that we get into. So we already have, as a company, we have quite a few innovation centers across various locations where we invite our clients and our companies to come in and look at what innovations that we have across the payment space. And then we co-create with them. So it may be banks with whom we work with regularly, even automobile companies. There are a lot of connected car equipments, connected car companies who want to have payment capabilities within their car. So when these companies are coming in, joining together, and it's the same in all open innovation stuff that we've been doing for quite some time now. So that area has already developed a bit. So I would say the same aspects and contracts applies to this sort of a joint development. And there could be various arrangements in which the companies and stakeholders who are coming into that joint development could share as a joint IP or specific parts of the creation, depending on who brings in what, may own the separate different parts of the IP that is created.
Thank you, Surendra. When it comes to co-creation, he used the word co-creation very nicely. Even recently, there was an initiative by Government of India on the Smart India Hackathon contest, where even there was a proposal document which said the companies, it could be private organization, government organization, they can bring the problem statement forward in front of the student community. 50% of IP will always be owned by the companies who are really hosting the hackathon. Then the rest 50% rests with the students. And then if at all the company wants to purchase the whole IP, they can make money and purchase. They can even initiate a product development for the ideas that are created, or they can recruit the students inside. So unless there is some kind of joint IP ownership or sharing possibilities, the collaboration and progression in invention development becomes a very difficult issue. With open innovation, co-creation, lot of startups, joint IP sharing, lot of effort and hard work is being carried out in India towards progress of our nation and IoT development. With such hard efforts, people come to patent office and then file patent applications for protecting their inventions. Let's ask Jaya, how much easy or difficult, or what are the challenges in getting a patent protection for IoT inventions in India?
Thank you. So, talking about the challenges, Dr. Schohe has already talked about enforceability related challenges. So I'll keep that point very brief. The first enforceability related challenge is definitely that the Indian legal system provides remedy only for direct infringement, and it can be challenging to assert your rights when there is contributory or induced infringement taking place. And owing to the nature of IoT, I think that instances of contributory infringement may increase, and therefore the law may have to provide a solution to that as well. Another problem is about lack of extraterritorial protection, and Dr. Schohe covered that. As in, if you have sensors extracting data in one place, however, your technical process is implemented in a server outside the jurisdiction, how do you then enforce your patent? So I'll not cover it in too much details, but I'll skip to the point where I want to focus on challenges relating to prosecuting IoT-related inventions in India, and I want to talk a little bit about subject matter eligibility. Now, earlier in my discussion, I talked about the types of inventions that are taking place in the 4 stages of IoT. So we have a sense of what these inventions look like. Now, how will these inventions fare under the Indian Patent Act? Because the Act has carved out some exceptions. So the Act basically says that there are these few categories of subject matter which are not eligible for patent protection. For example, one of the provisions says that mere arrangement or rearrangement of things working in a known way is not patentable. Another exception is that, just mere mental acts cannot be patented. Another subsection says mathematical method, business method, algorithm, or computer program per se cannot be patented. Presentation of information cannot be patented. Now, my sense is that the exclusion that is going to be carved out of it's actually Section 3 of our Act. The exclusions that are being carved out are going to impact a lot of IoT-related inventions. And while I could talk a lot about, what the objections could be that the applicant can expect from the patent office and how to work around it, I'd just like to focus on 2 categories of exclusions today. One is algorithm, and the second is computer program per se. So we have a Section 3K in our Act which says mathematical method, business method, computer program per se, and algorithms are barred. Business method, mathematical method, and algorithm have a complete bar, but computer programs are barred only to the extent that they are per se or as such. So what really is an algorithm? Or what really is a computer program versus computer program per se? The thing is that we do not have clarity related this in our Act. Also, the CRI guidelines, which is guidelines for examination of computer-related inventions issued by the Indian Patent Office for the patent examiners, does not provide a lot of clarity. However, some clues that we get is, if you want to come outside the purview of per se. So if you have computer program per se, it's not eligible. If you have something which is outside the purview of per se, it is eligible. So how do you work around it? So if you can establish that, your claim or the subject matter that you're trying to protect has a technical effect that will result in a practical application, that is one way of securing your patent protection. But then you'll have to establish your practical application, and that causes a certain degree of challenge to the applicant, because now your claims have to be worded accordingly. You'll need to provide a technical solution to a technical problem. You'll have to establish that what you're trying to protect is actually a technical process, which is providing a technical solution to a technical problem. Or you may need to show hardware-software interaction in your claim. So one challenge relating to prosecution of IoT inventions is that the claim drafting will have to become very, very specific. I also talked about the excluded category of algorithms. This is actually a challenge because the definition of this exclusion of algorithm is actually very, very broad. If we see the definition given in the CRI guidelines, it actually seems that this exclusion will impact a lot of IoT-related inventions. So law definitely needs to bring in more clarity. We've also seen that other jurisdictions have amended their guidelines to take cognizance of emerging technologies. We see that EPO has amended its guidelines to include emerging technology. They have revised their guidelines for examination of AI and blockchain-related inventions. Earlier this year, USPTO also updated its guidelines, and they've revised their guidelines for 101, which is subject matter eligibility. So the Indian office will also have to take cognizance of what is happening around the world. The Indian Patent Office will probably also sooner than later update its guidelines. And law in general will need to keep pace with the technology. You know, if we are going to address the problems that the applicants are facing, lawmakers will have to keep pace with the advances that are being made in technology.
Thank you, Jaya. I think she made the right point. There is a tendency to correlate the existing exceptions for patentability to the emerging technologies. What we faced earlier in the name of computer implemented inventions. The same thing, IoT means aggregation of equipments together. But it clearly says mere aggregation is not patentable, but we have to show synergy, which is much more than mere arrangement or rearrangement. So that is the burden, but I think we should be able to show over time. But given the complex nature of it, we are not sure whether we can show it well or not. That could be one challenging situation. The second one, she brought the point that the mental act, any mental act is not patentable, but in technology, there are computer chips which are called neuromorphic chips. They will resemble human brain. Whatever they do will be looking like mental act only. How are we going to get protection for them? So the developed countries have already made guidelines on how these kind of inventions must be examined. And it is good for the Indian Patent Office also to have a watch on what is going on and then make sure we also have some guidelines as our awareness itself is increasing in the area of IoT and artificial intelligence. We talked about the neuromorphic processors, and that's also called neural networks. We'll ask Stefan about what kind of issues are there in protecting inventions relating to artificial intelligence, especially in the context of neural networks.
Yeah, as I mentioned, this was a topic that the EPO actively discussed with the users last year. Before I embark on a bit more specifics about artificial intelligence and how the EPO now thinks of approaching it, let me just say that we have exclusions that basically are the same as in Indian patent law. And we also have developed concepts that you need to have a technical solution to a technical problem. Regarding the exclusion of computer programs, we say if you claim a computer or a method of running a computer, that's not claiming a computer program, so basically that's a technicality. But we have also a decision saying if the program has the potential to create a further technical effect beyond the normal operation of a computer, you can patent it. Now, with artificial intelligence, when you look at it, it's basically a very sophisticated algorithm or mathematical method that's carried out in a computer. Now, what do you do with that? Generally, and that's standing case law, is if you run it on a computer, it's not per se included, but the question arises in the context of inventive step, do you have a technical solution to a technical problem? And again, there is a simple case when you use your algorithm to control a machine or to process data that come from a sensor. That's accepted, that's technical, that's something you can touch with your hand. But what about the invisible things that you mentioned before? That happens and all you have is input and output. Again, there is a notion, and it's actually in principle acknowledged, that a computer is a technical machine. So basically, if you change the operation of this machine, that could be patentable as well, and this could be changed by an algorithm, but this is only undisputed when you come to low-level software. When you're talking processor architecture, operating system, when you come to application software, the issue is divided, and there are two schools of thinking. The one is that you say, well, all you do is you have an algorithm, mathematical method, which we do not patent, they put it on a computer, and then the computer does what it's supposed to be. It processes algorithm, it's not inventive, we don't patent that. That's one school of thinking. And that's, so that they say we want to see something beyond mere data processing. This, in my eyes, incorrectly links to this further technical effect that was somewhere, sometime in the case law. The other school says, well, irrespective of what level of abstraction you're talking, it's still a computer processing things. And now you have to think a bit more sophisticated about, namely, given the problem you have, what do you want to achieve? And was it then obvious to apply this algorithm in a computer? This is the other line of thinking. Now, think about what I told you before about data mining. You have a huge amount of input data, pictures, trillions, zillions, whatever. And you have an output, basically, okay, this is a picture of the GIPC 2019. Then some people will say, hey, this is just normal data processing, which we do not patent. And other people say, well, but actually we couldn't do it before. You could ask any computer scientist 10 years ago, they would say it's impossible. We don't do it, and especially we would have no way of telling, even if we, assuming we had the capability of searching these things in intelligent manner, which is not in itself, and there are specific mathematical techniques specifically designed of doing such things very, very fast, because even a computer has its limits. Apart from that, we couldn't do it, so that's an improvement. And now if you look at the economic side of things, you have a business, a big business that's called data mining, evaluation of data, or whatever. And now the big question for the next 5 or 6 years is, well, will the patent offices protect such inventions as I see them, or do they say, well, this is technology which we do not consider technical, we say incorrectly, in my opinion, that's mathematical, that's in the business regime, or whatever. So that's the critical question for the next years, and depending on which side the scale will tip, we may have a problem with protecting IoT inventions, artificial intelligence, or not. The current guidelines are not really encouraging that the EPO issued in November. They say, well, artificial intelligence especially is ultimately a mathematical algorithm, and we only patent this if there is a technical use, so there is a technical purpose, and by technical purpose they don't mean anything else in a technical word other than data processing. So if you use your artificial intelligence to control a machine, to take pictures, to organize a power grid, that's all fine. But when it comes to information processing, information selecting, etc., aka data mining, you may have a problem with that. So that's the current state of things now. I don't think this is the last word. We'll have to see how the case law develops, and I have to say that the guidelines unusually have been made ahead of the case law, because the EPO, and especially Grant Philpott, who heads the computer division of the EPO, says, well, we will have, no doubt, we will have boards of appeal deciding these things in 4 or 5 years, but the people now need guidance. So what we want to do now, we want to set up some rules, and then the users will know what the EPO will do, whether they like it or not, but at least there is some kind of security. You especially know which are the safe harbors. And then in a few years, we may look at it again when we have the Board of Appeal decisions. But for now, we need some guidance. And so it could also be that the EPO try to be on the cautious side, not to go too far, stay on safe grounds. That's my interpretation of the rules, because I'm an optimist. A more generic issue is, however, also how do you patent artificial intelligence in general? And to that end, I have to go a bit into technology. I hope it will not get too complicated. In a normal data processing application, you make a program and say, okay, I take this data, and then I take this processing step, this processing step, this processing step, and at the end there is a result. And if you go through all the logic of your program, you know the outcome. So you can directly correlate input to output. In artificial intelligence, especially neural networks, you do something different. You say, I set up a logic structure which I actually adapt to my specific problem in a way that I change the correlations between the elements. It's actually like in a brain. In a brain you have neurons, they're connected, and the way these connections are in the brain, in the human brain, are made depending on you can do certain things or not, and some neurons are fused together, some are not, and that basically establishes the power of our brain to do things that don't follow a logic law necessarily, but seem to come out of the blue. Likewise here, what you do now is you have this structure, you have the parameters, the connections, variable, and then you just give this system plenty of pictures. You say, okay, this is a cat, this is a dog. And you do this millions of times, trillions of times. And ultimately, and every time when you get the right answer, you enforce the system connections. If you get the wrong answer, you change your connections in the system. And ultimately, that's the beauty of it, your system will actually recognize what's a cat and a dog. However, it's completely intransparent for human, and especially you cannot foresee how ultimately the data are processed from input to output. So there is no apparent causal relation between input and output. That's one problem. And the second thing is you don't actually know how this system is internally structured. You only know, okay, if I throw millions of data on it, do it right and wrong, we call this training, then I end up with a system, and the system will do what I expect. So you have a problem of characterizing the system. You don't know its precise structure. You can, in fact, only characterize it by the training process, how you trained it, what data you showed it, how many times, in which sequence, etc. And even then, you may not have still tell, does, from an expert point of view, does it really what it's supposed to do? In this regard, the EPO was actually quite liberal, and they said, well, we accept this is a new technology, We accept that the training process determines actually the artificial intelligence neural network. And yes, provided you have your technical application, you have technical purpose, you apply it in a conventional field of technology, then we accept the training data as something patentable and the training process as something patentable. But you need ultimately to use the system for what they call a technical purpose. Another issue that may arise, and if biotech people are in the room, they may hear something familiar. Since you do not know the causal relation between input and output, the examiner may at some point actually request evidence that a system trained in a certain way really does what you say it does to the examiner. Because, let's face it, neural networks, artificial intelligence as such, are known. And if you just make a claim, I use training data, train my system, and then I get it, and then I can recognize things or control the machine, the examiner will say, well, at this generic level, that's obvious, because you know that what neural networks are good for. To use them is an obvious thing, and you don't say anything more, so it's not patentable. So you really have to be specific about your training process, specific about your specific neural network, and then you may have to prove at a certain time to the examiner, well, and if I do this, this actually distinguishes a dog from a cat, or more relevant, it distinguishes a pedestrian from a signpost, or whatever you want to have, for example, in automotive applications. Again, we'll have to see how this works out. Currently, there are some positive things, some negative things, but a big challenge for the patent office is how they do with the handling of big data, how they deal with data mining, how do they deal with improvements in basically handling big amounts of data. That remains to be seen.
Thank you, Stefan. I think you have extremely valuable points about the artificial intelligence and neural networks relate to mining of data and decision making. Data mining resulting in decision making happens within the computer. The input and output is both the data. The way you train the system, if there is uniqueness and if there is a commercial application, yes, it is patentable. European Patent Office allows. Beyond that, merely stopping at decision making alone is challenging to get patent rights. But applying the decision making into commercial use, anything that helps mankind to solve technical problems, yes, it is patentable. That's the summary of what Stefan was trying to explain to us. That was a very good insight, Stefan. Given that the IoT, AI, there is complexity in even getting a patent, even more to that in India, there is, first of all, lack of awareness of the patenting system itself. In this situation, let us ask the final question to Surendra, how he deals with creating inventions in the payment space in his company.
Yeah, thanks, Lakshmi. This is the last question. I'll try to make it quick so that we have some time for Q&A. So most of the things have been mentioned by Jaya and Dr. Stefan on how it's difficult to get these inventions patented or take it to the patent office and prove patentability. So on the other end, I have to work a lot with inventors and explain to them what is patentable and not, which I think is a more difficult task than talking to the patent office, because inventors always feels that they have the best invention and all their invention should be patentable. They don't have this concept of patentable subject matter and things like that. So to explain to them what is patentable, what is not patentable, what can be done and what cannot be done is a bit of a challenge. So the first challenge generally that comes up is what exactly is the invention. Sometimes we get ideas which are a combination of a lot of things which may be known. So figuring out exactly what is the invention within that is generally a challenge in itself. So if I take a hypothetical example, this is not a real example. So if somebody comes up, and we get things like this is not real, but similar things comes up, that somebody may say that I have an invention about a headphone, which may have an inbuilt music streaming system, wherein you can listen to device music when you are just putting on the headphone directly, and you can play your things that you want, and once in a while there may be a song which is just released and may not be available for free or part of your plan that you have. And to pay for that song, you can use your payment credentials, which are tokenized onto the phone through a hardware device, and you can use authentication of your ear scan for making the payment. So all these things are known. There are things around, there are research papers which say that every human has a unique ear print which can be used for authentication, and there are payment systems based on that. So all these things combined into one single idea. So making out exactly what the invention is that can be patentable, or a combination of all of these things. What is the patentability? Would it be obvious or not? This is a challenge in itself. So that takes some sort of awareness and educations within the inventor community that we try to do regularly. Apart from that, there is a challenge around whether the invention is around the technology itself or the concept itself or an application of it. So as we talked a lot about blockchain or AI or tokenization, there could be ways on how you are tokenizing the credit card data onto a device. So that's a technology in itself. So if there's an invention there or innovation there, that's easier to explain and get going ahead with. But if it's an application of that to different systems, so tokenized data, as we said, it can be applied to payments in a smart car or a refrigerator or a washing machine or a headphone. So then that becomes difficult to explain to those guys that it's an application level invention, and we may come across non-obviousness issues. So that's the other challenge. The final challenge, if I may say, is around what we again talked a lot about, is algorithms and computer models or business models, things like that. And we have a lot of those things that come up in our, say, fraud detection modules and payment data analysis modules. So one thing is that we have a lot of trade secrets that we keep inside. Not everything is patentable, and especially around the network transaction processing systems and the fraud detection systems. There are a lot of machine learning algorithms that are kept as trade secret because, one, we want to keep it as a secret, and secondly, it may not pass the patentability test. And secondly, when we are dealing with these type of cases, I think some of you may have heard Ajay in the morning in the first session today. He was from MasterCard, so it seemed they have similar issues. He was talking about similar things today, that we try to break down the black box, that what is this algorithm trying to achieve, how it is changing the things which are already there, what's the technical effect of it. Is it reducing the transaction processing time in some way? Is it helping us provide better targeted offers to the card holders in some way? Or is it helping us in a better fraud management system? And what is the difference? What is the improvement that we are bringing about because of the effect or implementation of this algorithm? If we are able to get some of that makes a stronger case for us to go ahead. So these are some of the challenges that we generally face in our space.
Thank you, Surendra. I think it is agreeable that in a country like India, where there is an emphasis and need for creating high number of patents and intellectual property, the fundamental problems still exist in the workplace regarding what are the different types of intellectual property, what is novelty, inventive step, what is a trade secret, how to come up with innovative ideas. Given that most of us are from the similar kind of a background, where we are all trying to help our company create more and more intellectual property and manage them well, I think it is time to now leave the floor open for any questions that you may want to interact with the panels now. Thank you. We have approximately 8 minutes. There's a timer running here. And any questions are welcome. Thank you.
Hello. This is Arvinda Panda from Lex Protector. So my question is mainly on the payment gateway and things out there. So you are mentioning that for a plastic money, you get it tokenized, and then there is authentication and then payment for the IoT device. So how Visa and how you or the patents community see a cryptocurrency as to be a payment mode and for IoT devices, and keeping that into a blockchain so that it get verified at any point of time. and how patents on these things are going into. Because many of the countries, obviously, cryptocurrencies are not allowed at this point of time, so as India. But obviously, some patents, since we have an office in Estonia, they are completely okay with cryptocurrency, mode of payment and all. So inventions out there is coming up, and how India is also looking into this kind of inventions, apart from the old technique of plastic money, currency.
Yeah, so applicability of cryptocurrencies in jurisdiction or governments across the world is more of a government-related issue, whether they accept it or not, what do they allow or not. From a technical or a payment perspective or a patent perspective, cryptocurrencies, as of now, the most common Bitcoin is based on the blockchain technology. So what's the technology behind it, and what's the innovation that's coming up? Is there any new inventive step or a technical effect that's coming up there? That could be patentable, and what I hear from our legal friends here is that still there are no granted patents or really granted patents basically around that idea. So around the world, there are patents being filed. All companies have been filing a lot of patents on blockchain technologies, but how are they received or examined by the patent office? What would the course be? It's still to be seen. Apart from that, a lot of things are already known. Again, it's a question like I talked about, is it the technology or the application? Most of the ideas that we are seeing are around the application, which may have the regular patentability issues that may face in terms of non-obviousness and novelty. If there are innovations around technology, the blockchain technology itself, all related technologies, that definitely may be more patentable, patent-worthy, because it's not only in cryptocurrencies. Blockchain as a technology is being used in a lot of different areas and domains. So, there are a lot of patents coming around that part of it, which would be more patentable than the application part of it, be it cryptocurrency or other things.
If I may add a point. So wanted to add one more point to that, Surendra, is that the invention can relate to cryptocurrency, blockchain, or for any other thing for that matter. What really is important is how you actually define it in your claims. You know, the wording, the claim language, the drafting of the claim is very, very important, because the assessment is going to be the language that you have put in the claims, the boundary of the IP that you drew. So claim drafting for all these emerging technology has become very important. So you have to actually look into the language very critically. Because the assessment test, you know, subject matter eligibility, novelty, inventive step, they are all going to be applied on what was actually presented in black and white to the patent office, and not really the invention that the inventor had in his mind.
Yeah. You want to add something? She has a question. There's one more question. Yeah, let's get it.
Then we'll close.
Yeah.
Hi, I'm Ira. I am from Wipro. I have had the opportunity to understand and study privacy laws, and what I notice is that consent is the big elephant in the room. Everybody seems to be trying to solve that problem, especially in the IoT context. Do you guys generally tend to see inventions or solutions, which try and deal with the problem of consent?
Well, I'm not a data protection lawyer, but obviously that's a big thing. You may have heard that in Europe we have now a very restrictive regime of data protection, general data protection regulation, which basically does not allow us to store addresses, telephone numbers of our employees more than absolutely necessary, with plenty of rights, etc. And that would be a talk by itself. Now, the legislator is a bit behind the time. They think of specific data, but if you think about the data mining, it's these days that in order to identify a person or to find out personal details about a person, you don't need to have an address, a telephone number, or something. You may have a bunch of communication records, you may have some pictures from a conference, etc., etc., and suddenly people, a clever data mining algorithm will know what you did today. Probably some supervision camera when you entered here or whatever, and obviously that can get very personal information, and that will certainly be at some point a certain issue. Definitely there are restrictions how you're going to use this information, so probably will not be allowed to store it. But the interesting question is whether you have data that are derived from non-personal data that have personal information, and you process again to non-personal information. So no human ever sees the personal information. Still, it has an impact how this is to be dealt with. We have to see, but probably, I guess, our legislators in Germany or Europe, they will take another 10 years until they've understood the problem at all. That's my view of the legislative process here.
Thank you, Stefan. Thanks for your question. I'm not able to imagine inventions directly on taking consent because it's more of legal. But there are inventions around the consent theme itself. For example, are there applications or people taking my data without my consent? How can I detect? Such kind of inventions really come. And assuming that there is no user consent or delayed user consent, then automatically taking only select data and then keeping the rest within the device itself. So such workarounds are there, even then it is coming. Such things are emerging, but not directly on different ways of taking consent. Could be if it is camouflaged with UI UX, then I think there is some amount of patentability and goodness for the consumers also.
What I can just add a bit to it is what we call it as a PII, personally identifiable information. That can you identify an individual based on the data, like you were saying, the name or birth date or credit card number or social security number, which cannot be shared. What I have seen in recent times, especially after GDPR has come in, is that a lot of companies, like be it financial companies, credit card companies, or even all these other companies, digital companies, need the data to identify patterns and again make some offers and recommendations. So in that case, what some terms that I have seen was how do you pseudo-anonymize the data so that you cannot identify who does the data belong to, but still you have a big set of data so that you can use the data and extract some analytics out of it so that you can make specific recommendation to that set of people or individuals without getting into individual space. So there are some inventions around that, but again, it's more on the algorithmic side or machine learning side of it.
And Surendra, I've seen, like you said, with GDPR coming in, I've seen increase in number of inventions, say, relating to data masking, where PII will be masked, you know. And you recall earlier I mentioned law has to keep pace with technology. When I see inventions like this, I feel sometimes technology also has to keep pace with law because, you know, there's a regulatory compliance. And so comply with that, we're trying to provide technical solutions.
Yeah, a great example of technology keeping up with law was demonetization for us. How in a day, a lot of new ideas came up, technologies came up to make up for the latest regulations.
Thank you, Surendra, Jaya, and Stefan. I think today we all discussed the IP issues and how they are addressed or possible to address in the IoT environment. I think the interest levels on deployment of IoT and the business is accelerating day by day from what we heard from Dr. Vinayak also. 20 billion devices are going to be connected by end of 2020. Legal framework is yet to gain higher maturity. With all this, there is no doubt that a well-managed IP is always good and profitable for the business. I thank all the panelists, Dr. Vinayak, A.S. Rao, who is not able to make it, Stefan, Surendra, Jaya, and all the audience, the organizers, GIPC today, for having a great time spent together. Thank you very much for your patience. Thank you.
I now request Mr. Lakshmi